Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, and I'm here every Sunday from 8 to 9 a.m. on these stations to give you, the landowner, valuable information that you need regarding the natural gas development here in Pennsylvania. And at the Clark Law Firm, my focus is on landowner negotiations and representation for all oil and gas related matters, and that's all I do. I don't represent companies, pipeline companies, gas companies, never have and never will. Okay, so also just a little more about me. As you know, if you listen to the show every week, here's kind of my little intro part. I represent landowners, gas lease negotiations, amendments and modifications, gas lease extensions, essentially any representation surrounding the oil and gas lease, pipeline right-of-way agreements, water line agreements, compressor station, just finished the compressor station agreement recently, estate planning, do more and more estate planning work for clients of mine who were prior clients who are now entering the royalty phase of their lease, which is a very fun time for a lot of people. But then also new clients who I didn't do their gas lease or pipeline agreements, but also are looking to have some estate planning done as well. So my opinion on that, again, as I say often, and even with other agreements, you need, as the landowner, you need a plan, an estate plan tailored for you, not for your neighbor, not for a group of people. You need it tailored for you, because you start throwing in two people, yet alone a group, and you're going to have some different needs there. So there's no single plan out there that fits everyone, and that's very important. So whether I'm involved or another attorney's involved, and you'll hear me say that often, because there are other attorneys out there, make sure that you are getting assistance, you're getting quality assistance, assistance that you can count on, that you're comfortable with, and we want to make sure that you're getting the right plan for you. Another thing that we've been working on a lot recently are unitization issues, and more often than you would think happens, we're seeing issues with landowners' decimal interest, meaning that maybe the company miscalculated what your interest is in a given well. Maybe the company has not attributed to you the correct acres that they should. So we're seeing on occasion where landowners are receiving less royalty payments than actually what they're entitled to. And usually, in my opinion, in most cases, it's just simply a mistake that needs to be corrected. But sometimes we do see a little bit more. We see companies maybe who we feel violated the terms of the lease because of the way they formed the unit, or maybe they enlarged a unit that they didn't have permission to do. So we're seeing a lot more of that. I often say this is an evolutionary process. We started doing with all these gas leases. Now we continue to do gas leases, but we start to see a lot more now with royalty-related issues. Whether it be unitization, the payment of royalties, deduction issues, estate planning issues, we're seeing more and more of those type of issues come up as we have evolved, if you will, through this process. So with all that, if you are looking for representation, again, I don't like to make this a big commercial, but you can always contact me directly, 570-307-0702. That's 570-307-0702. And here's my website. Make sure you go check out PAGasleaseattorney.com, pipelineattorney.com. Gasleaseattorney.com will have this radio show posted up Monday morning. And we've been working on, I've been doing the radio show since August of 2010. So we are working on, as we revamped and renovated the sites, we're putting up the shows and we're working on adding some each week. But we do have the very good fortune of being busy representing our landowner clients. So we're doing that as we can, but obviously we have some other more pressing matters with ongoing representation. So, okay, what I'm going to talk about today is, and I say this, sometimes people maybe listen and say, boy, he sounds like a broken record at times, but I'm going to talk about some pipeline right-of-way agreement again here today. And I talk about pipeline right-of-way agreements a lot because I see them so often. And if we're talking about the masses in the state, in oil and gas areas, and now even more, more of these lines that are going across the state in regions where gas development isn't even occurring. In the southern Pennsylvania regions, the lines going from the Pittsburgh area and west out through Philadelphia and even further east. So pipelines are the number one activity that I see out there today in the state. And I represent clients all over the state. Client now in Greene County, Pennsylvania, client in Butler, client in Allegheny County, clients in Armstrong County, clients all across the state, and of course the northeastern part of the state as well. And I'll say this, and I say this because I think it's really important. When you're listening to the show or you're going to be represented, you want to understand who the person is. What are their experience? What is their experience? You need to know these things. Should be important to you, and it gives you some perspective. Hey, do I know what I'm talking about? Am I just throwing things out there? What's my experience? And I've done pipeline right-of-way agreements. I haven't counted them up, but certainly I would say it's fair to say into the hundreds. And I'm at about 50 negotiations with about 50 different companies all across the state. So I have a pretty good idea of what companies will agree to, understanding how to evaluate leverage, which to me I think is maybe the most important part of that process, is understanding the leverage in your case. The message boards are great. You can get some good information out there, but I assure you, from a person who's done right-of-way agreements and negotiations with about 50 different companies, they can help you, but they can only take you so far. You need to understand your situation. You need to understand your leverage, and you need to understand the company you're dealing with. And most importantly, you need to understand what your offer is, what the terminology is in that offer, and you need to make that offer. If you're going to ultimately sign it, you're going to need to make that offer the best offer that you can possibly get. You have to do that because these agreements are extremely company friendly. Extremely. Well, another thing that I deal with a lot now, and have a few different clients, not several, but a few right now. One client, their right-of-way was signed in the 1930s. There's a right-of-way agreement signed in the 1930s. Then the company who holds that right-of-way is now using that agreement. And they're changing the line that was installed, or they're renovating the line. And these are things that we see into the future. So when you're looking today, you may say, well, look, hey, it's going to be 80 years. What do I care? But it may not be 80 years. Maybe it's 20 years. Maybe it's 10. Maybe it's 50. Maybe it affects you, but maybe it doesn't. Maybe it affects your children. So you want to make sure that you're doing the best you can for today and then also for the future. And I'm not talking, this is talking about the types of limitations you can put into these agreements. Not talking about compensation, the money you're going to get. You obviously want to maximize that as well. Another important part, maybe back 50 years ago, having a pipeline right-of-way agreement if somebody was going to buy a property and there was an easement on the property. Maybe that wasn't that big of an impact because they said, hey, wait, this pipeline's been in there for 50 years and everything has been silent. So the buyer says, yeah, well, that doesn't really concern me too much. A house is already on the property. Nothing has occurred. There's a pipeline there. You never see it. You wouldn't even know it's there if you didn't see it on your deed. Well, now, if a smart buyer is going to look and say, you know what? I understand there's a whole lot of pipelines being put into the ground now. There are a whole lot of pipelines that are still to come. So if I'm going to buy a property and I see there's an easement and I see that easement allows an unlimited number of pipelines, or maybe it allows 2 or 3 pipelines, and that's all. But even though it only allows 2 or 3 pipelines, there's only one in the ground. So I'm concerned, are they going to come back and dig up this property? And under this old agreement, I'm not going to get any money. It may put a pipeline closer to my house, which is something I don't want. It may be in an area where I want to do other things, maybe a barn, a garage, whatever it is that I want to do. Is that going to occur? So you have to watch out for those things. You say, you know what? I'm not comfortable buying this property because of this easement, because I'm aware that this is occurring now, and I'm concerned that it might occur in the future. Or maybe, you know what? Instead of an offer of $100,000, I'll offer you 70, or whatever that case may be, whatever numbers we want to throw out there. So the point is, is that a good agreement can also preserve the value of your property, not only for you and your family today as far as what's going to happen on the property, but also if you limit that. In my example, if that was just a pipeline agreement that said one line and one line only, and there's a line in there, and maybe it even said something like you can't increase the size of the pipeline unless I agree, well, you know what? That's going to probably not be much of an impact for me as a potential buyer. I'm not going to be so concerned about that. That's not going to be good leverage for me to try to undercut you and give you a smaller offer. So those are things that we need to think about as well. And we see those things because they're actually occurring where pipelines are being installed under old agreements that people just probably went ahead and signed because they're really form agreements. They're usually only a page long. And now the owner of the property has to deal with this bad situation. And maybe it's not the same person that signed. Sometimes it is. Maybe it's that person's child, or maybe that's somebody that's completely unrelated, but they have a problem now. So we want to make sure that we're thinking about everything we can think about and use our experience to get the best possible agreement, or possibly you can just say no. No, thank you. Not interested in the pipeline right away agreement. Okay, I am Attorney Doug Clark. You're listening to All Things Marcellus, and I'm here every Sunday from 8 to 9 a.m. Again, you can go back to pagasleaseattorney.com. If you haven't seen pagasleaseattorney.com, go check it out. And if you have seen it in the past, check it out again. It's renovated, all new, much, much better, a lot more information out there. So really encourage you to go check out pagasleaseattorney.com. So, okay. I'm going to go through a pipeline right-of-way agreement that is active in my office right now, and it's a newer one that I haven't seen verbatim, so I don't go through the same ones over and over again. I'm going to point out some of the problems, and I can tell already, because I did a kind of long intro, there's no way in the world I'm going to get to all the problems here. But let's begin. So, okay, it's called a right-of-way agreement. First thing it does is identify the parties. Then it says that the landowner intending to be bound receipt of $1 is acknowledged, and does promise that the company promises to pay the grantor, the landowner, any additional consideration. Okay, listen to this one. Upon completion of construction of any pipeline. So your next payment, so you're going to get paid your big payment if there is a big payment, but you're going to get your payment only after the pipeline installation or construction is completed. Well, when is that? Is that when the pipeline is in the ground? Is that when reclamation is finalized, which can take a very long time? I have several clients who are still dealing with reclamation aspects for pipelines that were installed last year. And it's a potential problem. So you need to understand those things. So we want to make sure that we set these pay terms in a way that's going to be acceptable. I don't know that I've had a client signing an agreement that called for payment upon completion of construction. Of the hundreds that I've done, I don't think I've ever had an agreement like that. So at very worst, you want to have it upon commencement of construction operations. You want to have it at least at commencement when they start, but not when they're done. But then it goes on to say that payment upon completion of construction of any pipeline makes me nervous because it's already talking about possibly more than one pipeline, based upon the total length of the final measurement thereof. So what it's saying is we're going to wait until we're done, and then we're going to pay you based upon how long the pipeline is. Well, do we know how long the pipeline is going to be? You have to have that question answered. So, and it's going to be based on the final measurement. So think about that. We're going to pay you when we're done, and we're going to pay you for what we've done. And as you're going to find out here, I'm up against this first segment. As you're going to find out here, we have no idea how long the pipeline is going to be or even where it's going to be. How do you sign this agreement? I'll be right back. There's so much more. Listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday from 8 to 9, and I'm going to be back right after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And if you miss any of today's show, or if you miss shows dating back to August of 2010, though they're not up at the all up at the website yet, you can go to pagasleaseattorney.com and check out today's show. It'll be up on tomorrow morning. You can get access to it. And we have, I don't even know how many now, but I think a dozen, 10, 20 shows, and we're working on adding shows here in the history with the new website. It's taking a little bit of time to get to everything. But we're putting up the shows as we can. But check out pagasleaseattorney.com. All right. So I want to get back into this pipeline right-of-way agreement. I'll tell you, I think it's going to start picking up here, okay? So this agreement, let me give you the end, and then we're going to walk through it. It's a terrible, terrible agreement, and I can't contemplate much of a situation where anyone should sign this agreement. So I'm going to just keep going through this, and of course everybody can do what they want, but listen to this. So it says when they're done with the pipeline, they're going to pay you based upon the length when they measure the pipeline, how long it is. It goes on to say that you as the landowner are granting to the company a perpetual, forever, exclusive easement. Exclusive to them, not to anyone else. It's their easement area. Now, a couple things on that. Them having an exclusive easement, they'll have the ability to assign or transfer or sell all or part of these rights to another company, but it's their exclusive easement. One of the things in this particular case, this pipeline right-of-way is proposed to potentially, because there's no guarantee here, to go across, say, the center of this property. Well, now you have an exclusive easement across the center of the property. There's a potential that this property with a gas lease, maybe the gas company wants to develop this property. Maybe this exclusive perpetual easement may create a problem for the gas company. And maybe you say, well, that's good because I really don't want the gas company to come on my property. Well, maybe the gas company says, hey, landowner, we had a gas lease here and we wanted to develop your property, and you went ahead and you gave this easement to a pipeline company, an exclusive perpetual easement, and we don't like that. And that may, I'm not saying we haven't seen it yet, but potentially that could be a problem. And there's ways to defend against that. And there's a whole, it would take a long time, but I just want to point out what to explain here. These are problems, or potential problems. And if that was the only problem, well, I still don't like it, and it still can be corrected. But there are so many more. So, okay, moving on then. So where is it going to be? So you're given a forever exclusive easement and right to locate, survey, construct, inspect, operate, protect, repair, alter, remove, or abandon, change the size of, and then this is great, in parentheses, anywhere within the property defined below. And then there's going to be a description here coming up. So they can locate the pipeline, they can change the size, they can abandon it, they can remove it, they can construct it anywhere within the property as defined below. Anywhere within the property. Right there. Anywhere within the property. You can't accept that. You cannot accept that. So it goes on. Establish, lay, install, test, substitute, renew, reconstruct, restore within a 50-foot wide right-of-way. 50-foot wide. We don't know where it is. We don't know where the pipeline is going to be located within the 50 feet. Is it going to be in the center of the 50 feet? Is it going to be 10 feet from the one side of the 50 feet? Where's it going to be located? So within 50-foot right-of-way, now keep listening because it just gets worse, together with all other necessary or convenient appurtenances, including but not limited to valves, drips, measuring equipment, pumps, electrical, and communication lines, collectively called the pipelines. So anytime that you see the word then pipelines after this, you know that means not only a pipeline or pipelines, but remember these other words, necessary, any other appurtenances, necessary or convenient, including but not limited to.
So these aren't the only things. These are just naming a few, but there could be more. So we're talking about valves, drips, measuring equipment, pumps, electrical communication lines, all of those things. But as you read on, all of those things, including other things that are necessary and convenient, are under the definition of the word pipelines. So brilliant. So now every time you read pipelines, you're just thinking about a pipeline. You're not thinking about a meter site. You're not thinking about a pig receiver. You're not thinking about valve site, measuring equipment. No, you're just thinking about pipelines. So it goes on then. They can perform any pre-construction, construction, repair, maintenance, replacement, and removal work on the pipelines. Okay. Now we would expect that. But of course, this could be anywhere in the property. Also then, have ingress to and egress from the right-of-way area. Well, how are they going to do that? By means of existing or future roads and other routes on the property, as defined below, and any adjoining lands. So they're getting ingress and egress, meaning to and from the right-of-way area, by means of existing or future roads and any other routes on the property, as is going to be defined below. So it then goes on to identify the property, saying that this property is, and it gives a property description, gives a tax map number, and I'm not going to say this information here. I don't want to identify this property. But then it says, as shown on Exhibit A, attached here to and made a part of. So in this case, we have a map. And this map shows the property. Here's something to watch out for landowners. We read earlier where it says this pipeline can be anywhere. Okay, what if we have a map that shows where the proposed pipeline is going to be located? Does that map supersede? Does it trump? Does it prevail over the idea that the agreement says, hey, this pipeline can be anywhere? And I'm telling you there, you need to identify that, because I think you have a problem there. If years later you say, hey, you can't put this pipeline here because there was a map. Well, that map doesn't say that that's where the pipeline has to be. That map just shows the property and there's a proposed pipeline there. But your agreement says, hey, it can be anywhere. It's written here, it can be anywhere. So, okay, we go on. It says, during temporary periods, grantee may use an additional 25 feet along and adjacent to the right-of-way, as may be reasonably necessary in connection with the rights herein granted. So during temporary periods, no definition here, but just during temporary periods, the company can use an additional 25 feet along the right-of-way. Goes on to state then, okay, so this is anywhere along the right-of-way. At locations such as roads, streams, ditches, or specific areas which require more difficult procedures, again, undefined, the company shall have such additional space as is reasonably necessary or convenient during the exercise of the rights herein granted. In my opinion, that language, all the company has to do is say, hey, we need to go a little wider here. And they'll say, they like to say for safety reasons or whatever those reasons are. But yeah, no, listen, when they go to cross a road, there's certain areas where they need additional workspace. But generally speaking, in almost all cases, we can define that area, not as is reasonable, necessary, and convenient. You can even define those areas by way of maps that are attached to the agreement. As a landowner, we want you to have the most clear document that there is. We want it to be certain, and we want to eliminate surprise. As a company, you want that document to be extremely broad. You don't mind it being vague. We don't want it to be. We want it to be clear, and we want it to be precise, and we want it to be narrow. Because think about this. In the future, are you going to go to the company and say, I don't want you to take out these trees here. These trees mean a lot to me. They block line of sight to the roadway. There's so many different reasons why you may not want an area of your property impacted. And the company says, well, look at your agreement. We can do it. We need this space because it's going to allow us, this is a tougher area and we need some extra space here. Well, are you going to go into court and fight them over these issues? Probably not. So you're probably stuck. But if your agreement defined an area where they could operate, if it was narrowly tailored to say you can only operate in this area, the company is not going to be able to go out of that without violating the terms of your agreement. So you need to be thinking about these things. No matter what that landman tells you, you need to document these items, especially if they're important to you. Okay. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday from 8 to 9 a.m. So going on then. So it says that the company shall have the right to install gates along the easement to provide unimpeded access. So the company has the right, not you, but the company shall have the right to install gates along the easement to provide unimpeded access. Think about that. You may end up getting gates in areas that you don't want them. This is along the right-of-way. It doesn't say necessarily here gates at each end of the right-of-way at the boundary, which actually as a landowner you may want to try to deter people from traveling up and down the right-of-way. And generally you can do that. What I like to do is to give that landowner or give the landowner client the option, because if you're sitting there and this right-of-way is going across the field, you may not want a gate because it's going to look pretty silly in the middle of a field that you have a gate. However, if you have tree lines, you're going to want maybe to have a gate, and actually not just a gate but fencing across the right-of-way, so you're going to deter people from driving up and down the right-of-way with their four-wheelers and their snowmobiles and things like that. So those are things you want to be thinking about as well. Have it happen all the time where clients say, we've created this thoroughfare, and in hunting season we see that a lot, where trespassers are just walking up and down rights-of-way across landowners' properties. So we want to be careful of that as well. All right, moving on. Grantees shall have the right to change the location of an installed pipeline and permanent right-of-way right-of-way area as may be necessary or advisable as a result of any conditions beyond its control, such as coal mining activities, ground slips, floods, road construction or relocation, or the like. So, okay, there's some things we can do about this. You don't usually see this language. There's a few things that makes me nervous, and there's some part to this that's somewhat reasonable. But we can do things like, we can move it to a reasonable distance with your approval, and usually that'll be not unreasonably withheld. But we don't want to see a right-of-way, and maybe you did a good job, and it says, hey, it has to be placed in a specific area, and maybe it's going to run along the border, but now they're going to run it across the middle of the property. Well, they need to do that. Could they just shift it a little bit more? So we want to have some more control over where this right-of-way can be shifted, and we need it to make sure that we're defining, too, that this is not just at the company's leisure, but it needs to be a necessity based upon, and one example, what I would say would be if a state was going to put a road in, and they wanted to go across the area the right of way, well, there's things that could occur there, so we got to watch out for that, or we got to be aware of that, and then we want to make sure that we're going to address that in the best possible way for the landowner. All right, up against it again here. I am Attorney Doug Clark. You're listening to All Things Marcellus here every Sunday from 8 to 9 a.m. I'm going to talk. I'm going to go through the rest of this. I think I can get through the rest of this agreement because it's not very long in this next segment. And then there's an addendum here. It's got one or two good things, but you wait till you hear this. All right, stay tuned. Attorney Doug Clark. This is All Things Marcellus. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark. I'm going to jump right into this because I want to get through this whole agreement. I've gone through a pipeline right-of-way agreement. It's a current active agreement that's being presented to a client of mine right now. And what I'm doing is going through this agreement, and I'm going to continue to go through their form agreement, and then I want to have some time. I'm going to go through the addendum here at the end. Okay, so where we left off, the next sentence reads that the company, and I use the word company instead of grantee, is further granted the right from time to time to lay an additional pipeline or pipelines alongside of or to connect with the first pipeline or any pipeline as herein provided. Okay, I'm going to have to go back on this one because this is a big term here. They're granted the right from time to time to lay additional pipeline or pipelines. So that means there's no limit here. No limit whatsoever. Additional pipeline or pipelines. Remember, how were pipelines defined previously? Not just a pipeline, but anything that was also necessary or convenient appurtenances, such as, but not limited to, valves, drips, measuring equipment, pumps, electrical and communication lines. That's what the word pipelines means here in this agreement. So they have the right to put an additional pipeline or pipelines under this agreement. So you may think you're getting one, but you could be getting multiple and multiple above ground appurtenances. Goes on. The company has the right to change the size of and replace any pipeline. So they can come in and make it bigger. You might have a 12-inch line now. They come back and they're going to put a 24-inch line in the future. So what do we want to do there? We want to make sure if that's going to happen, first we want to either say no, or we want to make sure that you're going to get compensated for that. Well, it goes on to state that damages, if any, to crops, timber, buildings, drain tile, and fences in making such change or replacement is to be paid by the company. So they're not saying they're going to give you any additional money other than whatever these damages are. Well, once you have this right-of-way there, probably you're not going to see that there's going to be trees there. So you're not going to end up seeing any timber damage in the future. Very unlikely unless it's maybe in that workspace area. You're not going to have a building in the right-of-way because you're not allowed to, as you'll hear here in a minute. So your chances of there being much compensation for damages is going to be very small. But then also, what if you're not happy with the damage payment? What do you do then? Are you going to go to court and fight that? So we want to make sure that we have vehicles, language in this agreement to make sure that they either can't do these things, or if they're going to do them, you're going to be compensated in a way that you feel is appropriate. So it goes on then to state that the landowner warrants and agrees to defend title to the property and also title to the property. Okay, and also releases any and all rights to dower. I'm not going to get into dower right now, but what I'm going to say is, so you're guaranteeing that you own this property, and if anybody ever made a claim in the future and there was a problem, well, you could be on the hook, or you would have to defend that. Generally speaking, you don't have to do this general warranty. Another thing is simple. You just get rid of that. Sometimes, in most cases, we don't have to warrant title at all. Or at the worst case, you just warrant title through you, that you haven't done anything fraudulent or done anything to cloud or damage this title. Moving on. Okay. Said pipeline shall be buried at the request of grantor, you, the landowner. So you have to request this so as not to interfere with any cultivation of the land. And the company shall pay reasonable damages which may arise to crops, timber, fences, buildings, and drain tile from laying, operating, maintaining, repairing, and replacing and removing said pipelines. We talked about that. Reasonable damages, they're saying here. So what your definition of reasonable and what theirs may be might not be the same. Any damages beyond the initial construction damages contemplated. So in other words, beyond these initial construction, any damages, if not mutually agreed upon, shall be ascertained and determined by 3 disinterested persons, one appointed by the company, one appointed by the landowner, and those 2 disinterested persons would appoint the 3rd person. Now you have 3. And the award of such 3 persons shall be final and conclusive. Each party shall pay the cost of their appraiser and shall share the cost of the 3rd appraiser. A few things there. We're talking about, they mention the word appraiser here in the second part of it, but there's no appraiser in the first part. Generally speaking, that whole 3 disinterested persons, a lot of times, that's implied that that's some sort of arbitration process. But then we have this appraiser process. So we need to be careful. We want to make sure that we have that defined. But then remember, that their appraiser or their arbitrator is going to be inclined to rule for them or give them a low estimate or appraisal. Your man or woman or your appraiser hopefully would have that same inclination towards you. So now it's going to come down to this 3rd person. However, each party shall pay the cost of their appraiser and share the cost of the 3rd. So now again, we need to be careful because if you have a dispute, how much is that dispute going to be? And what if you're going to have to pay these expenses? We don't want these expenses to outweigh the number of this dispute. Then what if you do need to get a lawyer? Now you have more expenses. We need to make sure that we have language in place that's going to avoid you incurring significant expenses in the event there's a dispute. You can mutually agree on one person and the company pay. There's a lot of different things that you can do here, a lot of different things, and I don't want to get too sidetracked, but I don't like that language. Anytime we start talking about 3 people being involved in disputes, that's going to deter the landowner from pursuing a potential very valid dispute because of the 3 people aspect, because of the cost of that. So please be careful when you see that language. I am Attorney Doug Clark. You're listening to All Things Marcellus here every Sunday from 8 to 9. If you miss any of today's show, you can go to pagasleaseattorney.com. Check out today's show. It'll be posted up on Monday morning. Okay. Goes on to state that, and I'm going to be quick on this one because I want to get through all this, that the landowner may fully use and enjoy the property, but they can't change the depth of the pipeline, can't put buildings, mobile homes, pavilions, shelters, storage units, trees, pools, etc., which in the opinion of the company could be considered an obstruction. So look, that's fairly normal language, but it's what you need to understand, that you can't put anything on top of this right-of-way. Now remember back to the beginning, this isn't a defined area of operations, so we want to be very careful about that. Well, first off, we're never going to run into that problem because we're never going to sign something like this. Goes on to state that the parties in this one, this is a bit like a legal terminology here, but this is pretty darn important. And the parties agree that the company, in its sole discretion, may elect to record this agreement, so may file it at the courthouse, or memorandum thereof in the county where the lands are located. So I want to go back on that. So the parties agree that the company, at its sole discretion, can either file this agreement or a memorandum of this agreement at the courthouse. Well, what if they don't file anything? What happens there? We need to make sure that this, if you're going to sign, that it's going to be documented. We would always prefer to get that agreement filed at the courthouse so there's no misunderstanding in the future. There's so much deed work going on now. All these agreements. If they're filing a memorandum, you need to make sure you're keeping a good copy of that agreement. Your attorney has a copy, that this copy of this agreement is being passed on, because the companies don't want to file these. They want to file memorandums. Well, a memorandum is just a document essentially giving notice that an agreement occurs. And they're written in a lot of different ways, but they're filed to show that they're demonstrating that there is an agreement between the parties, but they don't file the agreement. Well, if you're going to buy this property, you're going to sell this property, you sure as heck are going to want to see the agreement as the buyer, and you need to have it as the seller. So this company here is saying too, though, it's our entire discretion whether we even file a memorandum to tell third parties. You need to get that something filed. We prefer an agreement, but you need at least a memorandum. And you can't say, hey, company, yeah, whatever you want to do. Okay? Remember, they're asking you, this is your property. I am Attorney Doug Clark. This is All Things Marcellus here every Sunday from 8 to 9 a.m. on these stations. Okay, last part of this really is what we call the integration clause, which I have termed the landman free pass. And I'm seeing these, boy, they're in every agreement essentially. There's what we call boilerplate provision. Sometimes they're they're really wild when you read them. This one just says, it is understood that this agreement or this document contains all the expresses of all the agreements and obligations of the company in regard to the subject matter here, and that no covenant, agreement, or obligation not expressed herein, meaning not in this document, shall be imposed on the company. That again, I'm going to break away from the legal jargon there and say, look, here's what it is. We don't care what anyone said to you, what representations this landman made to you, what you think. If it's not written here, it doesn't count. That's what matters. And in some of these, when I say I'm starting to see more and more of these things be expanded, some of them, when you see this, look at it, it says, essentially, the person here dealing with does not have authority to bind our company. So they're even further distancing their landman from them. So just remember that. Look at these, and it's okay because they're ultimately going to be in there, but they're in there to give you notice, and you need to understand that. That person sitting at your kitchen table, that person calling you, that person being nice to you, has no authority to bind the company to anything. And whatever they've said to you doesn't matter if it's not in the agreement. That's what matters. They have the authority to get you to sign this agreement, but your agreement is solely what's written on that document. Just what's written on the document. What they tell you about, oh, we're not going to do this, or, oh, I don't see that happening. We're just going to put one line. Here's where we're going to put it. If you don't have that in writing, it does not matter. It does not matter. And if they're telling you these things, and look, turn it around to these people. If they're telling you, we're only going to put in one pipeline, we're going to put it here at this location, and you're good with that, you say, okay, fine. Put that down in writing and make it a part of the agreement. Now, I'm going to get back. We're going to talk about these addendum terms, but that's the end of this agreement. There's a statutory notice here, but I'm telling you, listen, that's the end of this agreement. You didn't hear anything about liability protection. You didn't hear anything about reclamation. How are they going to restore this property? That's the agreement. You heard a lot about they can put essentially all these different items as they define as pipelines without all the limitation is within a 50-foot of the area of the property. We don't even know where that's going to be, and you're going to get paid when they're done based upon how long this easement is. This is a horrible agreement that no landowner should sign. And what saddens me is I'm sure that many people have. And that's just a shame, because this is a terrible document that there's no reason that any landowner should be signing. And I know what the price is, and I'll tell you this, it's nowhere near enough. I'll be back. We got one more segment. I'm going to talk about this addendum, and I'll talk some more about some of these problems here. I'll be right back. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday from 8 to 9 a.m. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Going to jump right into this. Went through that right-of-way agreement, which is a current pending agreement with one of my clients. And I could do shows like this every single week. And every once in a while, I pick one of these out. And I'm going to keep doing this because they're really bad documents. This person would, if you sign that agreement, you just agreed to an undefined area of right-of-way on your property, access to and from this area, an unlimited number of pipelines, who knows what above ground and below ground. You've agreed to anything here. It's a terrible document. You didn't protect yourself from indemnification or liability issues. You didn't cover anything of reclamation. There are so many issues and problems here. You didn't define the location. There are so many major problems, and those are being presented to people, and they're signing them, and for too low of compensation, way too low. But even if you like the compensation, you can't leave something this open. This isn't 1934. This isn't 1950. This is 2015. You can't sign these. I've never had a client sign something like that, and I've never seen anyone sign anything close to that who was represented by any attorney who knew what they were doing. And my point is, you can't sign these. Whether you call me, call somebody who knows what they're doing. This is a terrible agreement. And you can say, in this person's case, you can say no, or you can get a much better agreement. You can get a much better agreement in almost every single case. I mean, literally, almost every single case, you can do better and significantly better. Don't be afraid to call somebody or say you're not interested, because you can't sign that type of an agreement. All right, I am Attorney Doug Clark. You're listening to All Things Marcellus. All right, I'm going to talk about, this person did do some negotiation before they came to me. And it was presented to me by the landman as though the landowner had all these great additional terms. So in this particular case, there's a price per foot compensation, which, again, in my opinion, is way too low. Let me say something in general. Everybody's different. I can't say something that you should do this or you should do that. I would have to look at your situation. But as a general principle, the idea of $15 a foot for pipeline rights of way, I don't like. I don't like at all. Most people are getting more than that. Some people aren't. Most people are getting more, and a lot of people are getting a lot more than that. So I do not like right-of-way agreements at $15 or around $15 a foot. The market in many areas are higher than that. So if you got that $15 per foot, my first question would be, do you have to agree to it? My second statement would be, look, I'm not interested. I think you're going to see those prices go up in areas where they're offering $15. I don't like it at all. I think those prices should be higher. Many other places, they're routinely getting $30, $31, $32 a foot as a routine base price. So please, you get $15 a foot. Just because that's what they paid other people doesn't mean that that's what they should pay you. And what's going to happen is people who don't sign now, in most cases, what you're going to see is that market change, and you signed, but somebody else is going to get more money, and they're not going to come back and make up the difference for you. Okay, just a general piece of advice, nothing specific for anyone. Listening to All Things Marcellus with me, Attorney Doug Clark. I'm going to talk about some addendum terms here. So it's a price per foot. Now listen to this. Listen closely to this. Why do we have an addendum? Why do we have additional terms? Well, we have those because we want to make sure we're making this agreement better, and we want to change the terms in the original document. Well, this document that was sent to me by the landman and given to my client says, this agreement, this addendum, shall not abrogate or alter any portion of the aforementioned right-of-way agreement. Well, isn't that what we want to do? Isn't that the basis of this? What in the world does that mean? Does that mean that you have no idea what you're even talking about? Does that mean this was a mistake? Are you making these kind of mistakes? Is this a trick? What does that mean? Because this is the whole purpose. We want to change the terms of the agreement. And in fact, the information after this changes what was conflicting with the terms of the right-of-way agreement. So you're saying that this language does not alter the right-of-way agreement? Then why is it there? Clearly, the intent is, in my mind, to change the agreement, to alter the agreement. So do you want to be fighting about this? And then right across the top of it says this page shall not be recorded with the all capitals, underline of the word not, and after the word recorded is an exclamation point. So do you want to get into a fight whether this document even exists? You got, and there's no place for the company to sign. So you have this addendum. You can make this up yourself at home. So, okay. Well, if you did, I hope we made up a better one. All right, so it goes on, and we have some additional stipulations. In this case, there is language about above-ground appurtenances. However, I don't like this language. I think it needs to be more clear. We need to definitively indicate that there will be no above-ground appurtenances and under any terms and circumstances unless agreed to by you, the landowner. Then it goes on, there is indemnification here. One of the things I want to say is, and it's good, very good to have some indemnification language, but indemnification language is not all written the same. So we want to have a strong indemnification provision, one that covers any and all liability as a result of a company's operations under the agreement. Why should there be limitations for you as the landowner? If you're making this agreement, the company should indemnify you if there's any problems from their operations. You should be covered for everything. Again, this is a case where we want it to be actually broad. In this one example, we want the liability to be very, very broad for you as the landowner. And they want to narrow it. So we want to make sure we're getting good language there. Then it goes on, and these are the things that always kill me. I was saying all these things about the different pipelines that is a big problem, and a lot of people were signing, and this person actually went to bat and was trying to negotiate. And it goes on here and says one pipeline only. That's the heading here, one pipeline only. But it says that there's one, they have one pipeline, and all appurtenances and equipment used for the construction and operations of the pipeline. Couple things. Right here, one pipeline and appurtenances. But previously, I just said there was some potential, or there was some above ground structure limitation language saying limiting things that could be above ground, but this seems to be conflicting to it. And above all else, the actual agreement says anything can be above ground that they want or is convenient, and this addendum says that it can't alter the agreement. So which one works? Which one do we look to? You've got to identify these. You have to take care of this. Although this heading says one pipeline only, I'm telling you that reading around one pipeline only says one pipeline, natural gas, but then says an appurtenances and equipment used for the construction and the operation of such pipeline. But then says this agreement also grants the laying of a water line within the same right of way. It is agreed that said water line shall be buried. So, although the heading is one pipeline, the provision actually permits one gas line and one water line. The heading says one pipeline only. The words say one gas line and also one buried water line. That's not one pipeline. A water line is a pipeline. Are they installed simultaneously? Are they installed on two different occasions? You can't leave these type of things open. The last one then is a timber stacking provision saying that they would stack timber along the edge of the right-of-way at areas accessible to the landowner. Now, there's all kinds of problems potentially with that. Are they going to be stacked in one location all along the right-of-way? If you're going to have timber stacking, you need to be thinking about these provisions because a lot of people are having problems because the timber is all mixed and the forester and the guys coming in to get it don't even want it. So there's ways to try to combat that, and you need to try to do that. But I don't want to get stuck on that right now. So that's the end of this. Okay, that's the end of the addendum. Nowhere does it define the location of where this right-of-way can be located. Nowhere. You know what else it doesn't say? When does this agreement kick in? When are you going to get paid? It's designed to be paid after the operations are complete. Now, again, you can negotiate and say, okay, I want to have a commencement before. Well, how long do they have? 5 years, 1 year, 2 years? We see it all the time. Oh, we're in a hurry. We're going to start next year. Okay, put it in the agreement. No problem. If I'm going to agree to this, I'm okay with that. Put it in the agreement. Well, we can't maybe do that. All of those things. Anytime they tell you something, say, okay, I'd like to see that as part of the agreement. Any single thing they say to you, say, okay, I'd like to see that as part of the agreement. Well, we can't do that. We can't do that. Then why are you telling me that? Because you know what? You have this language here that says everything you tell me, if it's not in the agreement, doesn't count. But you're telling me all these different things, and you're telling me we can't put them in the agreement. Think about that, everyone. Think about that. All of those promises, that are said to you. They say those things to you and say, here's what we're going to do. Here's what we're going to do. But then they tell you, we can't put it in the agreement, what I just told you. But when you look at the agreement says that anything that anyone else tells you, if it's not written down, doesn't matter. You need to understand that. Okay. Oh, boy, there's so much more, and I'm getting fired up, and I only have 10 seconds left. All right, you're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Check out PAGasleaseAttorney.com. Check it out. You need any representation, 570-307-0702. Hope this was helpful. Have a great week, everyone.